Good afternoon. Today, I will be speaking on behalf of my client, Odyssey, who has been subject to an unlawful termination of the contract involving themselves and the defendant. This is a case which demonstrates the consequences of a contractual relationship initiated by my clients and pursued with dishonest and profit-seeking ambitions from the defendant. The initiation of a commercial contract, or any contract, as we all know, should be signed in good faith and with the intent of commencing a contractual relationship that is fair and, most importantly, will be complied with by both parties, along with the responsibilities each party is prescribed and has agreed to follow. The defendant has been served and brought to this arbitral tribunal for their negligent approach to the development of the project, their lack of commitment to the deal, and the financial consequences that caused harm to my client. The relationship between my client and the defendant began in 2008, while my client was in search of wind energy projects their company could develop. After much consideration, both my client and the defendant became engaged in 5 projects, governed by the special project contracts. The roles of each company were clear from the beginning, and the defendant held an important role as the financial source of the responsible development of these projects, which, if not dealt with closely, can cause harmful impacts on the environment. The problem arises when the defendant became reluctant in carrying out and financing the relevant studies in order to make sure that the development of these infrastructures were up to standard according to domestic regulations. This began around 2 or 3 years after the contracts were signed, and the projects were yet not in development, which for this purpose meant that the defendant was not allowed to withdraw from the contract, according to Spanish law. My client insisted against the negligence of the defendant to carry out the studies, highlighting the essential nature of pursuing such action. However, the defendant ignored the persistent request from my client, and at this point, my client began to understand the deceitful intentions of the defendant to withdraw from the contract. By 2011, and with the crash of the economy, the opportunistic defendant claimed that it was withdrawing from the contract for the financial impact it could cause on their assets. However, and as it has been proven, the energy area of the economy was not particularly harmed by the financial crisis. We can see that the intentions of the defendant are clear from the beginning, since the moment they negligently refused to finance these studies relevant to the development of the project, by trying to unlawfully exit a contract, leaving my client to bear the consequences. Thank you.
Honorable Tribunal, first and foremost, I would like to express gratitude on behalf of myself and my client, Parthenon Energy, for granting the opportunity to present our defense before you here today. While my client respects the view of the claimant and understands the difficulties that may arise from the termination of the 5 equal special project contracts signed on October 1st, there is a considerably great amount of evidence which serves to illustrate that my client had no other choice but to take recourse to this action, given the force majeure nature of the current economic situation in Greece. Contrary to what the claimant mentioned, this contractual related into by my good faith, with the reasonable expectation that the projects were wholly feasible and could therefore be developed pursuant to the terms stipulated within the contracts. However, experts can also attest to the fact that the advancement of the financial crisis, especially with regards to the renewable energy sector, is nothing short of disastrous. The rising amount of debt and monetary instability, along with the failure to inaugurate a new government, makes Greece a volatile and highly unsafe market to invest in. This is demonstrated by the fact that investment in renewable energy has already plummeted to unprecedented levels. Thus, out of duty to itself and other entities within the Colossus Energy Group, my client is duly inclined to withdraw from the contract and make no further investments in the Greek market. This action is fully permissible by virtue of Article 4 of the Special Project Contract, under which the withdrawal of either party may be done during the development stage of the process. This stage is defined as either before the startup of construction works or the financial closing of the project. As a matter of fact, problems with the closing of the project finance structure was the underlying reason for several discrepancies that eventually led to the initiation of this arbitration procedure. Despite the good intentions and pure motives of Parthenon Energy to resolve these disagreements through a generous offer to renegotiate the contract on terms better suited to the claimant, this attempt was struck down before any viable proposal could be discussed. Therefore, it may be said with certainty that the termination letter was sent by my client within the required time frame and is therefore valid. Moreover, my client demonstrated highest regard and due diligence to avoid further conflict and try to continue with the projects, unfortunately to no avail. Now, on a separate note, the compensation for terminating the contracts enshrined within that same clause orders my client to pay 50% of the remaining payments of the project. Evidently, this money simply cannot be paid by my client because it currently has no project that has reached the stage of energy production, thereby giving it zero income. Its financing is obtained fully through loans from its parent company, Colossus Energy. Due to the fact that Colossus Energy is not the titular of this partnership agreement, the claimant has no right to request such payment, as Parthenon is a separate legal entity, meaning no action may be taken against Colossus for the obligations of its subsidiary. Notwithstanding, Parthenon Energy still fully agrees to transfer all shares of the jointly incorporated company, Sparta SPV, to Odessy Energy for an agreed price of €5,000. To conclude, it is with greatest regret and condolences that we proclaim the end of this partnership. But the opposing party must also acknowledge the reality of the global economic crisis as not just an inconvenience for this project, but a circumstance which will undoubtedly result in similar situations for many other businesses and enterprises alike. I thank you most respectfully for your time and attention.